Can adult children legally put their parent's second spouse out of a family home when their parent dies? What does the law have to say about property when it comes to common law unions? Are you building on family land? Do you have a legal claim to family land? Do you have a will? Do you even need one? What do the laws say regarding property and the transfer of property? We're back at Finisterre Law to ask these questions and many more. Why? Because a lot of the conversations we've been having have been around acquiring property and renovating property, but a large part of being a good steward of your home is making sure you know where it goes when the time comes. I'm Kelly Johnley, and we're in for a very serious and spicy conversation on Bajan Renovation. Faye, we're here to speak about property transfer, wills, estate, probate, and these things that tend to consume us, right, at very difficult junctures of our lives. But we're not talking about them at a time that we can really do anything about it. As someone who has seen it all, tell me, who should be having these conversations?
Every person should be having these conversations. There's nothing certain but death and taxes. So in the event that your loved ones are going to be dealing with your estate at a difficult time when you are no longer with them, sometimes unexpectedly, you want to be able to buffer and you want to give them some sort of certainty during that period. Discuss estate planning. It is not just for the rich and famous or people who have loads of assets, who have 10 acres of land and 2 houses. Whatever you have that you've inherited, that you've purchased, that you've worked hard for in your life, and you want to ensure that it's directed a certain way and managed in a certain manner, you can't rule from the grave. So a will, it really is your best chance. And estate planning is for everyone.
Okay. Within the context of property, what is a will and why does it matter?
A will is basically the last wishes of the testator. The testator is the person who is making the will. They appoint someone who's called an executor, and that person basically will take in all of their assets when they die, and they will administer those assets according to the wishes of the testator that are contained in the will. So basically, it's how do you want things to go after you die?
I have seen in the papers, and you hear it in discussions usually when someone has passed, someone dies intestate, right? I assume that means that there is an out of testate. What does it mean to die intestate or out of testate?
Okay, and intestate means that that part of your assets is not covered by a will, basically.
Okay.
And you could die partially intestate and partially testate. So you could have a will that says what to do with your house.
Okay.
But you've forgotten to say what to do with your jewelry, your personal effects, your car, your bank accounts. That part of your estate will be deemed to be intestate.
Okay. I also hear, and I see it in the papers, right, that someone's estate is in probate, right? What does it mean when your estate is in probate?
So probate is the process, the legal process of proving the validity of a will.
Okay.
And it also can colloquially refer to the administration of a will.
Administration of a will. Now, some people, you hear it, we hear things. This thing has been in probate forever, all right? Where does this forever come from? I guess this is the part that keeps you all very busy. When someone has been in probate for a long time, why?
Well, they might mean that it's in probate as in it's in the probate department,
okay,
which is a division of the Supreme Court of Judicature. So, we have the civil, we have criminal, we've got family. There's also a probate division. And they probably mean that it's stuck in probate as in it's still in the process of being proved, and it's in the probate department.
All right. Asking all the serious questions because I have the spicy questions for later. Is there a way to avoid having your estate go to probate? or this is just a process?
It is just a process.
Okay.
The will has to be proved. You have to prove that it's a valid will, because otherwise somebody could fraudulently create a document, forge a signature. And wills also have like formal requirements, legal requirements, 2 witnesses. It must be signed by the testator in front of those 2 witnesses. It has formal requirements. So there's also, during the probate process, an opportunity to challenge a will.
Yes, I've heard about people challenging wills.
Yes, so you have to go through the process to prove the validity of the will and to ensure that's also the person's last will, because there might be another will hanging around that we're not sure of. And that includes like doing searches to make sure that that's the person's last will.
Now, in the event that someone passes without a will, I get the impression, just from conversations, and you can correct me if I'm wrong, a lot of people die without putting a will or any provision for property in place. When that happens, what happens next?
Well, if you would like to deal with that person's estate, you would have to make an application for letters of administration, which is an application to the same probate department to be appointed as equivalent to an executor with the same sort of powers. You become an administrator of the estate, and you have the legal possession of that person's assets, and then you manage and distribute those assets according to the rules of intestacy.
Okay. All right, guys, I've asked all the official questions, and I will now ask the questions that y'all want me to have answered. So if somebody dies, right, and there is no will, or there is a will, do the laws of Barbados, right, regarding matters of estate, will that supersede a will?
Yes.
Okay, so the big question is this. We have a lot of blended families in Barbados. A lot of blended families, or a lot of what I call informal living arrangements. And I hear this all the time. I was living with my aunt, uncle, cousin, sister, friend. I put money into the property. I've been paying the land tax bill for the last 10 years. I built on the bedroom. When the person who technically owns the property passes, the other person now, where does that leave them?
Well, unless they are a beneficiary under the will, if that person left a will, or they're a beneficiary under the rules of intestacy, or there is a deed amongst the family members which formalize any arrangement that they had, then that person just ends up being a creditor for the money that they've spent in the estate.
Okay, so you do not have technically, you cannot say that, okay, I put $50,000 into this $100,000 house, and therefore half of this house is automatically mine.
It's not automatic, no.
There's nothing automatic here except the laws of what provision is made under the law and what has been requested in the will. And that is what is honored first, the laws of Barbados, and then what you request.
Yes.
All right, so another thing now that you hear about quite often is family land. If I had $1 for every time someone says, oh no, I'm building, we have family land, or my grandmother said that I can build on the land, or my grandfather died and none of my cousin, sister, brother, boyfriend, friend, nobody is in the house. I've been living in the house. Legally, whose house is this? And does the person who's now going and making these improvements, do they legally own this house now on this family land?
No. The only person...
It's no fair. I think you need to say it louder for the people in the back.
I said no because I wanted to soften the blow.
Okay.
But the answer, unfortunately, is no. The only person that's the owner of the land is the person who's the registered owner of the land. That is the person who's on the title deed or whose name is at the land registration office. That's the only person who's the owner of the land. That's the only person who can divest themselves of the land, transfer the land, leave it in a will, or make plans for the distribution of it.
So I just want to be very clear. My mother has a piece of land. I have my mother who is married, not to my father. My mother who is married, hypothetically, to someone who is not my father, owns a piece of land. My siblings and I were told that we could build on the land. I have gone and built my house on the land. All right. I go to the bank now, and they, of course, the bank wants me to be able to prove that, I have assets because I want to do other things. What position am I in now?
The position you're in is you have no title to the property, but you've put money into something that's fixed to the property, unless it's a chattel house.
Yeah.
what you ought to do is formalize that arrangement with your mother. If your mother is alive, you go to her and you try to formalize that arrangement.
Okay.
Because the only person that can give you, there's a saying in law, nemo dat non quod habit. You can't give what you don't have.
Own.
If you don't have it, you can't give it. So the mother is the only one that's in a position to give you anything. So you would like to go to her while she's alive and ask her maybe to make a deed of gift, transferring that property to you, or transferring the property to you outright, like in a sale.
And if mom was to pass now and nothing has been done, right? It is the laws of the country that will then govern, right, the transfer of the property.
Yes.
And I think, just speaking off camera, you had shared that this does not go to automatically to grandchildren or anything like that. There are layers to this, and in order to challenge it, you have to challenge at each. You have to do letters of administration that may address mom's siblings, and then any aunties and uncles, and then
so there are
Wow.
rules of intestacy, and you have to follow those rules of intestacy. There is basically a pecking order, which is what we call the rules of intestacy, where if someone dies without a will, you must follow the administration of the estate according to those rules. That's how you have to deal out the cards.
Okay.
This one first, then that one first, and if there's none of these, then that one gets the share. That's how it is. Very, very clearly set out the Succession Act.
All right. So would I be correct in saying to all of you who I know have been on family land or who are improving properties that you legally do not own, and living in a house forever don't mean you legally own it, correct?
No.
That you need to regularize your relationship with the property?
Yes. That's the best advice.
That's the best advice. And I know a lot of us might say, in terms of our assets, technically speaking, until you own it, right? It has been transferred to you, it's in a deed, it is not your asset. So it is not collateral for anything.
No. Unfortunately, it's the person who that has the deeds that owns the property.
So I know within your firm, Finisterre Law, you all deal with a lot of these types of cases. What are some of the common things that come up?
This family land misunderstanding, where people think that because they have an agreement with their family members that is binding.
It's a big deal.
It's not, because people spend, as you say, they go and they spend money improving properties, put in wall house where a chattel house used to be, and once the wall house is done, the wall house now becomes part of the property. You just enrich the property owner. So if the best way to approach these family arrangements is to go to a lawyer and formalize it. Get it just put into a deed. If somebody wants to say, I'm not interested in granddaddy's share, I'm not interested in the property, I'm not interested in getting a piece of land, they could put that into a deed. You could literally formalize all of these things, but unless it's formalized in writing, then you really just rolling the dice with your money investing in family property.
Okay, going to move it a bit, the conversation a bit into a mortgage space, because many of us are acquiring properties through a mortgage. The person who has the mortgage, they pass away, right? Where does the bank come into all of this? I do know that some people, myself included, are required to take out life insurance, which will cover, I believe, was the amount of the mortgage which I borrowed. In that instance, correct me if I'm wrong, and I pass away, the policy will respond. It will clear the balance at the bank, and then the property now goes to, I guess you say, my estate.
Yes.
Where the laws of Barbados or the will distribute the property. Okay, this is correct?
Yes, that's correct. It will then go
something.
past to your estate.
Okay, it will then pass to my estate. I don't know if it is a requirement of the bank, all the banks. It has been a requirement with me, at least each time I went to a bank. But would you say it makes sense then, if you have a property that you have a mortgage on and you want to at least make sure that your family can benefit directly from it, that you take out a life insurance policy that is assigned to the mortgage?
Yes, that's the smartest thing to do. That's one of the main reasons people use life insurance policies, is to cover their mortgage payments.
Right.
Because otherwise you'll be leaving your family a debt, and they have to satisfy that debt. The bank is not going to be concerned with the fact that you've died. The asset has now been transferred to your estate. So it could be your executor, or it could be to your administrator if you've taken out letters of administration.
Okay, so in the event that the bank has not required this, it is in your best interest to make sure the life insurance policy is assigned to the mortgage? Because I know a lot of people that do have life insurance policies and it's not assigned. Right? So that still leaves the mortgage in a precarious situation where it still has to be paid.
You could leave the money to a beneficiary who's going to pay off that mortgage, but you have to ensure that you trust that person to use those funds to pay off the mortgage.
Okay. So now that we have stirred people's ants' nests, we do not want to create family discord. This is meant to be informative. Yes. We find out, we're hearing this information, we don't have a will, right? Or we were living on family land and we don't know what are the next steps. What are the next steps? I'm hearing this for the first time. I'm in shock. I'm looking around like, oh God, please don't die. Where do I go?
Well, if you are the owner of the property, then I suggest that you start looking at your assets. Start making plans for your assets. Have a discussion with your family. Even if you're the person living on the land, go and have a discussion with your family and see if you can formalize those arrangements. So if you are the testator, the person who owns the property, then I suggest that you get a will and put all of your last wishes in writing, because that's the only way to guarantee, to a certain extent, because there are reservations there, to guarantee that your last wishes are going to be carried out in the way that you intend. And if you're someone who is a daughter living on family land and you've taken your salary to fix the house and everybody's benefiting from it, with this understanding that you're going to be the one to benefit when the ownership in case granddaddy dies, then go and have a conversation with your grandfather. Go have a conversation with the rest of the family. Try to get it formalized. It can be formalized in a number of ways. It could be a transfer. The grandfather might decide, I'll transfer the property to you right now by giving a deed of gift and reserving a life interest where for the remainder of his life, he's allowed to remain in his house. And when he dies, it will officially become your property.
So just because someone did ask me about that. A property can be transferred while I am alive.
Yes.
And so you said our option one way is a deed of gift.
You could, especially during family, because why would you want to charge family any money for the property? So you could do a deed of gift to a family member and retain. The smartest thing to do is to retain a life interest for yourself, because it's your home you want to live in.
Until I die.
Until I die, this is my home. When I die, it's yours to do what you want with.
Okay.
So you kill two birds with one stone there.
Okay. I've been using that phrase a lot. Killing two birds with one stone. Is there anything else I can do? So we said deed of gift. We said get a will.
Get a will. That makes it very clear what it is you want done with your property and who you want it to go to. So the grandfather might say, well, you all have seen Felicia putting her money into this property, paying all the bills and the land tax.
Yes, because we know we're big on this land tax. Banks like a job letter and we like a land tax bill. I paid it.
So they could say, well, I'm going to leave the house to Felicia because she's the one who's been taking her salary and basically sustaining the rest of the family. That could be in the will. Alternatively, you could ask the other family members to go all to a lawyer and say in this deed what has been agreed, and everybody signs off on it, and then it becomes binding on everyone.
And then it becomes binding. This is a spicy question because we have a lot of blended families in Barbados, a lot, and something very uncomfortable that a lot of people are dealing with. Let's say two grown people get married. When I say grown, meaning that these people have adult children. So they get married, Mr. Johnson and Mrs. Johnson now, and they're both in their 70s. They get married and they go and live in the home of Mr. Johnson. Mr. Johnson dies. Mr. Johnson has children, right? He has a spouse who is not the mother of these children. And then you hear that the second Mrs. Johnson is being asked to come out the house because he left the house to the children. What do you do with this?
Well, we've seen this more than once.
I have heard about it, and I mean, I'm not even a lawyer, where people are told they need to leave matrimonial homes because matrimonial homes are left to children, adult children. Where's the law on this?
Well, the law does protect the spouse in this case.
The law protects the spouse. Go ahead.
So even if you leave a will, you could say, I'm leaving $10,000 to my wife in the will, and that's all you want her to get when you die. And your adult children are very happy with that because they get a matrimonial home.
Right.
That's not where it ends. It doesn't end with your will. Even though we say you have testamentary freedom in Barbados, there are a bit of limitations on that under the Succession Act. The spouse can decide no, I don't want $10,000. I want the house.
Okay.
As long as the estate is of sufficient value, they can ask for that house. And it starts with the spouse, and that is man or woman, has a right under the Succession Act to ask for and elect, instead of what's left for them, 50% of their deceased spouse's estate.
So it's not no automatic, no. My dad left the house to me, my mom left the house to me, you need to come out the house.
That person, unless they're poorly advised, and they should be advised by the executors anyway, they have a right to elect for half of the estate. And then they have a further right to elect to ask for the matrimonial home in satisfaction of that half.
Because the estate is not just a property. An estate is really all of your worldly possession and debts.
Yes, and debts.
And debts, okay? Because people like to come for the assets, but you know, my understanding is debts need to be settled before assets can be transferred. So you might have a house valued at $300,000 and your credit card bills, and all of these, you know, sole proprietorship bills and stuff like that. The house will then have to satisfy the debts first, and what is left will then satisfy
the distribution.
Yes. Hope y'all are all right. So this is getting spicy now. I hope y'all are still okay. People create wills. Can you update a will?
It's advisable to update your will as your life circumstances change. So if you gain an asset, you buy a house, you sell a house, you have a kid, you have another kid, you leave your woman, you leave your man, somebody dies. As your life circumstances change, your will should change.
So speaking of circumstances change, and we can just speak frankly here because we are grown and we see this happening a lot. There are people who are married and then they separate, right? It is clear they have separated. Both of them have moved on to different romantic pursuits. They never legally got divorced, right? They set up their lives and they have their understanding, right? Then someone dies, right? And now all of a sudden we were married, right? But sometimes people go on and have other children. People go on and do a lot of other things. When you have these, what I now call dynamic relationships, right? And the way I see it, you know, fair exchange and a robbery. If you have decided amongst yourself, that's how you live in, fine. But when it comes to property now, and you guys have gone your separate ways, started up these lives with different people, and somebody dies, is your estate now in a mess? Is there a way to still ensure that the person who you are with can benefit from the estate?
Well, aside from having a will, the law will still treat your partner, your common law partner, as a spouse, as long as you have lived together for 5 years.
So I could be separated for 6, 10, however many years, my grown children gone along, and me and Auntie so have been living together for 5, 6 years, etc. The law will treat them as a common law spouse.
Yes, so Auntie so-and-so will be recognized as the spouse as long as she's been living with you as a spouse for 5 years.
Some of y'all could breathe a little easier now. Okay. All right. Well, this was enlightening. Any closing remarks from you as someone who has seen the good, the bad, and the ugly of estate planning or lack thereof?
Yes, my advice has not changed over the years. I just have the general advice for the public that estate planning is not just for the rich. It's not for people who have plenty things or plenty pieces of land. Whatever you have that you've worked hard for your life, that you have inherited from your parents, grandparents, you want to make plans for those things because you have no control from the grave. The only control you'll have is by leaving a will. So talk to your family, identify someone who you really trust as an executor, and make plans for what you want to happen to your assets in the likely event that you'll be gone, because the only two things that are certain is death and taxes.
And that's the end of that. We've touched on a lot today, and I hope we didn't stir the ants nest too much, but it is better to be informed. I'll underscore everything Faye Finisterre said. Start having the conversations. You've worked hard for what you have, and I know that you want to make sure that it benefits those who it is intended. I'm Kelly Johnley, and this is Bajan Renovation.